Welcome to Beyond the Arts. Let's get into it. In today's episode, we look into Warner Music Group versus others, which is related to one of the biggest songs the world has ever seen, which is Jerusalema by Master KG and Nomcebo. It's a very huge song. In South Africa, it has been a while since they experienced such a huge song. What happened was that during the pandemic, people started making dance challenges and it went viral. In these dance challenges, you see people in groups, different denominations, performing dance routines while the song Jerusalema is playing and they are dancing to the song. It became a viral dance challenge which went beyond the borders of South Africa, the borders of Africa, and reached the world. Something interesting then started to happen. Companies, organizations, and corporates joined into this challenge, where we started seeing police officers doing the challenges across the world, people in the medical space, and other organizations that were in the corporate space. It all went well for a while. People enjoyed the dance challenge, from young children and elders. Warner Music Group, as per the public domain records, started policing some of these dance challenges in a form of videos on social media. When big organizations continued to do the dance challenge and started showing their brands in the videos, that's when Warner Music started saying something is not right here. Warner Music's debate was that corporates joined in the dance challenge and the routine until, as it is alleged, that some companies and organizations started aligning the dance challenge with their brands, with their branding also, and their company names. Now they started to field into commercial benefits which are related to the licensing of music that is used in sync deals. The world of copyright is still struggling with a few concepts that are related to fair use and fair dealing. Some people debate that other people or institutions want to stretch the fair use into free use, which is why in South Africa, the Copyright Amendment Bill is now sitting with the Constitutional Court based on many challenges that have been facing this legislation. As and when the dance challenge connected to Jerusalem started spreading, airline companies started doing them, medical people and medical specialists started doing the dance challenge. This now also started to lean towards moral issues where people were debating that when it comes to medical practitioners, as people who were in the front line during the pandemic, having them dance to the song and join in the challenge was a form of them showing solidarity, support, and people were debating that this was not necessary for the copyright holders to go after such medical practitioners. On the other hand, there were many companies in Germany, as it is found in the public domain, who were then approached by the copyright holders, or in this case, let me say, Warner Music Group, to claim licensing fees from these people or organizations. Firstly, let's address the issue of how licensing for sync happens. I know I've touched on this in previous videos, but for the purpose of this video, it might be easier for me to reference it again. If you want to get licensing rights for sync, you need to look into two rights: the copyright in the sound recording and the copyright in the composition, which is loosely called publishing, and the copyright in the sound recording, which is loosely called the master. So you have to get license and permission from the sound recording holders. Most times, this is the record label if the person is signed. If this person is an independent artist, you will then have to speak to them directly to license the sound recording part of the song. Then you'll have to get license from a publisher if the composers of the work are signed somewhere else for publishing. If they are not, you'll have to speak to them for their composition so that you can be able to use the song in its entirety. The Jerusalem Challenge was performed using composition and sound recording as one. So meaning the master of the song was taken as is, including the composition of those writers respectively. If you don't get to clear those two rights, you are leaning towards infringement, which carries a lot of consequences. What then happened is that Warner Music then approached these companies in Germany to say, you have used our work without following the necessary processes, and you have no license and rights to use our song in your dance challenges to the benefit of your company from a commercial point of view. The argument was that you can use the song as is for your dance challenges as a company, as an organization, but once there's branding in the video, then the elements of license starts to kick in once there's commercial value to the company or the organization. Another point to ponder is that most people confuse the Facebook library that is there or the Meta library that is there, which covers Facebook and Instagram, to say if I find a song in Instagram or find a song in the Facebook library, it means that I do not need any license to use the song in my videos. Well, to some degree, those people are correct, but only for personal use. Once there is commercial benefits or it is used for commercial purposes, you will have to get a license. The Meta library and license will not cover you. And if you read their terms and conditions, you will understand that this is the case. And there's hefty fines if you don't abide. This now speaks to another fact that I have as an opinion from a point business and from a point of music business law. In principle, any person, whether an influencer, whether an individual who is using a song for a promotion that entails a brand, like you normally see where they say this is a paid promotion. Even if you use a song that you find on Facebook or Instagram, which is part of the Meta library, you will still need to get license to use that song as an influencer or as an individual. You don't have to be someone from a specific company for you to need a license, but the fact that you are promoting and advertising a certain brand which has commercial value for that brand, you will have to seek license. Most people don't think that they need the license to do influencing or to do brand placement. I'm here to let you know that you primarily need that type of a license. If a copyright holder identifies that you've been using their song as part of your brand promotion or brand partnership or a paid promotion, even if that song is part of the Meta library, you will have to face the full might of the law. So I hope you enjoyed my opinion when it comes to this matter, and I must say I am supporting the submissions of the copyright holders in this Jerusalema matter, where it is said that as long as there is economic benefits, you will have to seek a sync license for a dance challenge that comes with audio visuals and using a song that belongs to someone, especially if that song is owned by someone and the song is not in the public domain pool. Remember, this is not legal advice. This is just an opinion from my side. If you need legal advice, don't hesitate to consult a professional. Remember, we are here to assist you.